Everything explained in this video is summarized from the CoinMarketCap. And also, please don't forget to like and subscribe to my channel for future XRP news and some other cryptocurrency news in general. Now, take a look at this. XRP lawsuit court dates revealed amid SEC shutdown fears. An important set of dates for the explosive litigation that Bradley Sostak has brought against Ripple has just been disclosed by the United States Court of Appeals. While everything is going on, the United States Securities and Exchange Commission SEC is working hard to turn in its primary brief before Chairman Gary Gensler departs his position. However, there is a possibility that a shutdown of the government could cause delays. This is the reason. Ripple lawsuit. Important dates have been determined by the United States Supreme Court's appeals filing. The United States Court has mandated that the plaintiff, Bradley Sostak, submit a mediation questionnaire by the 23rd of December. Like immediately after that, the court anticipates receiving the appeals transcript order by the 31st of December and the whole transcript by the 30th of January. In the meantime, Sostak will submit his opening brief on March 6, 2025, detailing his allegations against Ripple and Brad Garlinghouse, the company's CEO, even though Ripple Labs, XRPI, and Garlinghouse are expected to respond by April 7, 2025. If either of the parties fails to satisfy these deadlines, the appeal may be rendered invalid. Previous decisions of the court, several past court verdicts that have been beneficial to Ripple, have been followed by the most recent announcement. Bradley Sostak's continuing to press forward with his accusations in spite of this current situation. Phyllis Hamilton, the judge, recently gave her approval to a motion that sought to modify the decision about the verdict and the stay in the case. Both parties agreed that there was no need to postpone the judgment because the class claims had already been settled, and they recommended a fresh order to address this consensus. Preparedness for the sexy shutdown. In the meantime, the Securities and Exchange Commission, which is also participating in the action against Ripple, is confronted with difficulties of its own. A potential shutdown of the United States government is getting closer and closer as a result of budgetary concerns. The issue may cause the Securities and Exchange Commission to delay its answer to the appeal, and some analysts have predicted that the continuing legal struggle may be put on hold. There is a possibility that this delay could alleviate some of the immediate strain that Ripple is under. Nevertheless, it may also delay any settlement that could offer clarity to the administrative position of XRP. According to the notice of appeal that was filed in the district court, a court of appeals in the United States has issued additional dates for the litigation against XRP. Particularly noteworthy is the fact that the opening brief is scheduled to be submitted on March 6 of the following year, while Ripple Labs, XRPU, and CEO Brad Garlinghouse are scheduled to submit their response to the appellant's major brief by April 7 of the following year. Before Gary Gensler departs from his position as chair of the Securities and Exchange Commission, the United States Securities and Exchange Commission is getting ready to submit its primary brief. Ripple XRP lawsuit release dates from the United States Court of Appeals following the confirmation that it had received notice of appeal. The United States Court of Appeals for the Ninth Circuit allocated a docket number to the action that Ripple was involved in. It was requested by the Court of Appeals that any motion seeking relief from this court be submitted differently. Within 14 days of receiving this notification, the plaintiff is required to submit a disclosure statement, which is analogous to the filing of appeals with the United States Securities and Exchange Commission, because the relevant documents were not submitted to the appeals court. The appeal in the XRP litigation should be dismissed. According to the order that was set, the plaintiff, Bradley Sostak, is required to submit the mediation questionnaire by the 23rd of December. The order for the appeal transcript and the appeal transcript are anticipated to be due on December 31 and January 30, respectively. Beginning on March 6, the plaintiff will present an opening brief, which will lay the groundwork for the appeals that will be filed against Ripple and CEO Brad Garlinghouse. Ripple Labs, XRPE, and Garlinghouse are required to submit their appeal answering briefs by the 7th of April. By the Ninth Circuit Rules of Procedure 10.3, the parties are required to designate and, if necessary, cross-designate the transcripts if there were reported hearings. It is the court's opinion that the transcript deadlines do not apply if there were no hearings that were reported. As was previously reported by CoinGate, the lead plaintiff, Bradley Sostak, filed an appeal against recent rulings that were in favor of Ripple Labs, XRP AI, and CEO Brad Garlinghouse. The district court ruled in favor of Ripple. In the case involving XRP, The application to amend the order regarding judgment and stay was granted by Judge Phyllis Hamilton. The court received a proposed order from both parties in which they agreed that there was no reason to delay judgment because the class claims had been addressed. Ripple versus SC, which is currently being heard in the Second Circuit Appeals Court, is the subject of attention. Executives from Ripple and members of the cryptocurrency community are optimistic about the possibility of the case being dropped or withdrawn. However, there have been some people who have expressed their worries that Gary Gensler may cause complications as he stands down on January 20, which is 5 days beyond the principal brief deadline. As the date of the hearing on January 15 draws near, the legal struggle that Ripple and the SEC have been engaged in has been gaining the upper hand. John Reed Stark, a former enforcement official for the Securities and Exchange Commission to seek into crypto skeptic, recently made an appearance on the podcast hosted by Docket Media LLC and discussed the historic rulings on Ripple. The Ripple verdict, according to him, does not give wide legal certainty and should only be applied to cases that have specific facts that are comparable to those in the Ripple case. In his criticism of the Ripple decision, he asserted that a great number of individuals had a misunderstanding of the finding, most likely because they had not read it in its entirety. According to him, Judge Torres was mistaken on multiple counts, which is a view that is held by other judges who have reviewed the case on multiple occasions. There are a great number of aspects of the Ripple ruling that people get completely wrong because, in my opinion, they did not read it. It is entirely not. I would like to express my sincere respect to the court of Torres by saying that I believe she was wrong on several counts, just like Judge Rakoff and every single other court that has considered that ruling. It was said by him, it was pointed out by Stark that the decision about Ripple was twofold. In the first place, he concurred with the contention that the initial offering of XRP tokens to sophisticated investors ought to have been registered as securities to safeguard those individuals. On the other hand, Stark was not in agreement with the choice regarding the secondary market, which was the environment in which XRP was exchanged on exchanges. Stay one step ahead of the competition in the Ripple versus sex drama by reading the XRP price prediction and gaining insight into the potential outcomes of this legal war for the market. The decision made by Ripple was confused. According to him, the idea that retail investors were not safeguarded since there was no direct contact between Ripple and them is an unjust argument. He believes that this reasoning is not fair. Stark contrasted it to the process of purchasing stocks in firms in which investors do not have a direct contractual relationship with the company, but are nonetheless protected by securities legislation. Additionally, Stark criticized the Ripple ruling for causing uncertainty, particularly after cryptocurrency supporting businesses started referencing it to argue that tokens were not securities, but rather cryptocurrencies. In response, the Securities and Exchange Commission, CDO, an interlocutory appeal in the hopes of putting an end to the procedures that were already underway.